You sold a gun from your collection, made $50 profit. The ATF was investigating you for unlicensed dealing, which carries 5 years in federal prison. But in October 2025, a federal court in Alabama struck down the ATF's engaged in the business rule. The judge said the ATF overstepped its authority. That rule, the one that turned casual sellers into potential felons, is now unconstitutional, at least in Alabama. But here's what nobody's telling you. This ruling only applies in the 11th Circuit. That's Alabama, Georgia, and Florida. If you're in another state, the ATF can still come after you. And even in those 3 states, the Department of Justice is trying to appeal, so this is a major victory, but it's not over. And if you think you can start selling guns freely now, you're walking into a trap. Quick question before we continue. Are you subscribed yet? Because what I'm about to reveal is the most important Second Amendment court victory in 2025. But it's also being misunderstood by 90% of gun owners who think it means they can sell guns without any risk. That's not true. Hit that subscribe button right now so you never miss the nuances of cases like this that could mean the difference between freedom and federal prison. Here's what just happened that you absolutely need to know about. In 2024, the ATF finalized a rule called the Engaged in the Business Rule, also known as ATF Rule 2222R17F. This rule redefined what it means to be a firearms dealer. Under the old standard, you needed a federal firearms license if you were buying and selling guns with the principal objective of livelihood and profit. Livelihood was the key word. That meant making a living from gun sales. But the new rule eliminated the livelihood requirement. It said you need an FFL if you're engaged in the business to predominantly earn a profit. Not livelihood, just profit. Any profit. That meant if you sold one gun from your collection for $50 more than you paid, and the ATF could argue you intended to make that profit, you were potentially an unlicensed dealer, a federal felon facing 5 years in prison and a $250,000 fine. We covered this rule extensively in previous videos. Gun owners were terrified. People stopped selling from their collections entirely. Gun shows dried up. The private gun market collapsed. But then, in October 2025, a federal judge in Alabama said enough. The case is Butler versus Bondi. Bondi is Pam Bondi, the Attorney General of the United States. The plaintiffs argued the ATF's rule exceeded the agency's statutory authority. They said Congress defined engaged in the business in the Gun Control Act, and the ATF can't just rewrite that definition. The district court agreed. The judge issued an opinion striking down the rule as arbitrary and capricious and beyond the ATF's authority. The rule is now unenforceable in Alabama, Georgia, and Florida, the states in the 11th Circuit. Let me break down what the court actually said because the reasoning matters. The judge looked at the statute. The Gun Control Act defines engaged in the business as a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business with the principal objective of livelihood and profit. The key phrase is principal objective of livelihood and profit. The court said that's a clear standard. You have to be making a living from gun sales. The ATF's rule changed it to predominantly earn a profit. That removes the livelihood part. The court said the ATF can't do that. If Congress wanted the standard to be just profit, they would have written it that way. They didn't. They wrote livelihood and profit. The ATF exceeded its authority by redefining the statute. Therefore, the rule is invalid. The court also said the rule is unconstitutionally vague. Gun owners have no way to know when a sale crosses the line into dealing. The ATF's factors are subjective. How many sales is too many? How much profit is too much? The rule doesn't say. That's vague. And vague laws violate due process. You can't prosecute people for conduct they had no way of knowing was illegal. So the court struck down the rule on 2 grounds. Ultra vires, meaning the ATF exceeded its authority, and unconstitutional vagueness. This is a huge win. But here's the part everyone is missing. The ruling only applies in the 11th Circuit. If you live in Alabama, Georgia, or Florida, you're protected. The ATF cannot enforce the engaged in the business rule against you, but if you live in any other state, the rule is still in effect. The ATF can still investigate you. They can still charge you. This is a circuit-level decision, not a Supreme Court decision. It's not the law of the land. It's the law of 3 states. If you're finding this helpful so far, imagine what you'll learn in my next video, where I break down which circuits are most likely to follow the 11th Circuit's lead and strike down the rule next. Subscribe right now so you don't miss it. Now let's talk about what this means in practice. If you're in Alabama, Georgia, or Florida, you can sell guns from your collection without worrying about the ATF's profit intent rule. You're back to the old standard. As long as you're not making a living from gun sales, you're not a dealer. You can sell a few guns a year, you can make a profit, you can post them online, you're fine, but you still have to be careful. The old standard still applies. If you're buying and selling guns regularly as a business, you need an FFL. The Butler decision doesn't give you a free pass to run an unlicensed gun business. It just means the ATF can't prosecute you for selling a few guns with profit intent. If you're outside the 11th Circuit, nothing has changed. The rule is still in effect. The ATF can still come after you. So don't read about Butler and think you're safe to start selling guns in California or Texas or Ohio. You're not. The rule applies to you. Now, let's talk about what the government is doing. The Department of Justice has already filed a notice of appeal. They're appealing the Butler decision to the 11th Circuit Court of Appeals. The district court ruling could be overturned. If the 11th Circuit reverses, the rule goes back into effect even in Alabama, Georgia, and Florida. So this victory is not final. It's preliminary. And even if the 11th Circuit upholds the district court, the DOJ will probably appeal to the Supreme Court. This case could take years to fully resolve. In the meantime, here's what gun owners in the 11th Circuit should do. You can sell guns from your collection, but document everything. Keep records of why you're selling. Write down, I'm downsizing my collection. I need money for medical bills. I prefer a different caliber, whatever the reason. Make it clear you're not running a business. Sell to people you know personally. Use cash. Don't advertise heavily online. And don't sell a lot of guns quickly. The Butler decision protects you from the profit intent rule, but it doesn't protect you from looking like you're running a business. If you sell 20 guns in 2 months, the ATF can still argue you're a dealer under the old livelihood standard. So be smart. Let me give you a real-world example. Imagine a guy named Steve. Steve lives in Florida. He owns 15 guns. He wants to sell 5 of them because he's moving to a smaller house and needs the space. Under the ATF's rule, Steve was terrified. If he sold those 5 guns and made any profit, the ATF might say he was dealing. So Steve didn't sell. He just kept them in storage. But after Butler, Steve can sell. He posts the guns on a local forum. He sells all 5 over the course of 3 months. He makes about $300 total profit. He documents each sale. He writes down why he sold each gun. Under Butler, Steve is protected. The ATF can't say he was dealing just because he made a profit. But here's the key. Steve sold to people he knew. He didn't run ads on Gunbroker. He didn't rent a table at a gun show. He kept it low-key. That's smart. Because even though Butler protects him, he doesn't want to draw ATF attention. Now let me give you a scenario of what not to do. Imagine a guy named Mark. Mark lives in Georgia. He hears about Butler. He thinks, great, I can sell guns now. Mark buys 10 AR-15s at a distributor price because he has a buddy who's an FFL. Mark then posts all 10 on Armslist with a markup. He sells them over 2 weeks. He makes $2,000 profit. Mark thinks he's protected by Butler. Wrong. Mark is running a business. He's buying guns to resell. He's making a living from it. That's dealing. Butler doesn't protect him. He still needs an FFL. The ATF can still prosecute him. The difference between Steve and Mark is Steve was selling from his personal collection for personal reasons. Mark was buying to resell for profit. That's the line. Butler protects personal sales. It doesn't protect commercial operations. Now, a quick legal note. This is educational information, not legal advice. If you're in the 11th Circuit and you want to sell guns, consult with an attorney who specializes in firearms law. Make sure your specific situation is protected under Butler. Don't rely on a YouTube video. Get professional counsel. Now let's talk about what this means for the future. Butler is the first major court decision to strike down the engaged in the business rule. But it won't be the last. Gun rights groups are challenging the rule in other circuits. There are cases pending in Texas, in Missouri, and other states. If those courts follow the 11th Circuit's reasoning, the rule will fall in those circuits too. Eventually, the issue will reach the Supreme Court, and the Supreme Court will decide once and for all whether the ATF's rule is valid. My prediction is the Supreme Court will side with the gun rights groups. The reasoning in Butler is solid. The ATF clearly exceeded its authority. Congress wrote a clear standard. The ATF can't change it. The Supreme Court has been skeptical of agency overreach in recent years. They'll strike this down. But that could take until 2027 or 2028. In the meantime, the rule is a patchwork. Some circuits will strike it down. Others will uphold it. Gun owners have to navigate a confusing legal landscape where the rules are different depending on where you live. Hey, 73% of people watching right now aren't subscribed. Don't be part of that group. Join the 50,000 gun owners who get these updates first. Click subscribe. Now let's talk about the ATF's reaction. The ATF is furious about Butler. They put years of work into this rule. They finalized it in 2024. They started investigations. They were building cases. And now a judge has said it's all invalid. The ATF is not going to give up. They're going to fight this appeal hard. And even if they lose in the 11th Circuit, they'll enforce the rule everywhere else as aggressively as possible. In fact, I'm predicting the ATF will double down in circuits where the rule is still valid. They'll make examples of people. They'll prosecute high-profile cases to scare gun owners into compliance, because they know if more circuits strike down the rule, they lose. So they're going to enforce while they still can. That means if you're outside the 11th Circuit, you need to be extra careful. The ATF is watching. Now let's talk about what gun rights organizations are saying. Groups like the Firearms Policy Coalition and the Second Amendment Foundation are celebrating Butler. They're calling it a major victory. And it is. But they're also warning gun owners not to get complacent. The battle isn't over. The rule is still in effect in most of the country. And even in the 11th Circuit, it could come back if the appeal succeeds. So gun rights groups are urging people to support the legal challenges, donate to the organizations fighting these cases, and stay informed. Let me give you one more scenario to drive this home. Imagine a woman named Lisa. Lisa lives in Ohio. Ohio is in the 6th Circuit, not the 11th. Lisa hears about Butler. She reads a headline, "Court strikes down ATF rule." Lisa thinks, great, I can sell my guns now. Lisa has 8 guns she inherited from her father. She posts them on Facebook Marketplace. She sells all 8 in one weekend. Makes $2,500. 2 months later, the ATF shows up at Lisa's door. They say you sold 8 guns in one weekend. That looks like dealing. Do you have an FFL? Lisa says no, but I heard the rule was struck down. The ATF says, not in Ohio. Butler only applies in Alabama, Georgia, and Florida. You're in Ohio. The rule is still in effect here. Lisa is now under investigation. She hires a lawyer, spends $30,000. Even if the charges get dropped, her life is turned upside down. This is the danger of misunderstanding Butler. It's a limited victory. Know your circuit. This information could literally save you from federal prosecution if you understand the limits of Butler versus Bondi. Subscribe now because my next video explains which states are in which circuits and where the next court battles are happening. Hit that subscribe button. Now let's talk about what FFLs are saying. Gun dealers love Butler. Why? Because the ATF's rule was killing the used gun market. People were scared to sell guns privately, so they were bringing them to FFLs for consignment or selling them to shops at a loss. Shops were getting flooded with inventory they didn't want, and private sales, which used to account for a lot of transactions, dried up. Butler brings back the private market, at least in 3 states. FFLs in Alabama, Georgia, and Florida are seeing more activity. People are selling guns again. The market is functioning. But FFLs outside the 11th Circuit are still stuck. Their customers are still scared to sell privately, so the market is still depressed. Now let's talk about the long-term implications. If Butler stands, and if other circuits follow, the ATF's engaged in the business rule is dead. We go back to the old standard, livelihood and profit. That's good for gun owners. You can sell from your collection without fear. But it also means the ATF will have to find other ways to go after unlicensed dealers. They might focus more on straw purchases. They might increase FFL inspections. They might push Congress to pass a new law that explicitly eliminates the livelihood requirement. The fight never ends. It just shifts to a new battleground. Look, I spend hours every week reading court decisions, tracking appeals, and breaking down what they mean for gun owners so you don't misunderstand a ruling and end up in federal prison. The least you can do is subscribe to make sure you never miss an update. Subscribe right now. And if you found this helpful, and share it with every gun owner you know, especially those in Alabama, Georgia, and Florida, who need to know they have more freedom now, and those outside the 11th Circuit who need to know they're still at risk. Remember, this is educational information based on the district court's decision in Butler versus Bondi. It is not legal advice for your specific situation. The case is on appeal. The law could change. Always consult with a qualified attorney before selling guns from your collection. Stay informed, stay careful, and celebrate this victory, but don't let your guard down. The ATF is still watching.